Production funding for Behind the Headlines is made possible in part by the WKNO Production Fund, the WKNO Endowment Fund, and by viewers like you. Thank you.
Crime, policing, and the consent decree tonight on Behind the Headlines. I'm Eric Barnes with the Daily Memphian. Thanks for joining us. I am joined tonight by Michael Rawlings, Director of the Police Department, Memphis Police Department. Thanks for being here.
Thank you for having me.
And Bruce McMullen is Chief Legal Officer for the City of Memphis. Thank you for being here.
Thanks for having me.
Along with Bill Dries, reporter with the Daily Memphian. I'm going to start with Bill giving us a kind of a quick primer on the consent decree, and then we can talk more about that, interpretations of it, its an impact, and you all were trying to get that modified. But Bill, why don't we start with just a background on the consent decree?
All right, we'll go pretty basic with this. 41 years ago in 1978, there was a lawsuit by the American Civil Liberties Union of Tennessee against the city of Memphis that was resolved with an agreement by all sides involved in the litigation in a consent decree. The issue in the lawsuit was political surveillance by the Memphis Police Department. There were some guidelines that were in the consent decree, in effect ground rules for this, that specifically said the police department cannot do quote unquote political surveillance. There's been a lot of debate then and since then over the last 41 years about exactly what the term political surveillance means. Fast forward to about the last 5 years when we've seen an increase in protest and activism, what some people have called the new activism in the city in the age of social media, and there have been some new questions about that, some new controversy about that, and what the police department has been doing in the last 5 years, which brought this case back to federal court.
Okay, so with that, and you all had gone, and I'll turn to the lawyer at the table here for a second. You all gone to federal judge John McCullough and asked for a modification to that consent decree. That on Wednesday night, overnight, was declined. Is that fair?
It was declined. We got a order from the court late yesterday addressing our motion to modify. And the court declined it, but the court did give us some guidance and some understanding on the court's interpretation, which ultimately that's all that matters, the court's interpretation of the consent decree and what are our limitations and what things are not our limitations.
So let's walk through that. So let's start with what you are asking for and then how you interpret. And I'll be fair, I have not read, and I don't think Bill, because this is all, as we're taping this is new, so we have not seen the judge's documents, but so we're gonna rely on you. What were you asking for, and again, what did you get from the guidance you described?
What precipitated us filing the motion to modify is that we have a monitor in place, Mr. Ed Stanton, and we would go to him with questions, and this is the process, about what we can and cannot do under the consent decree. And early on, there was a police symposium here on September 11th, and we had a number of 65 dignitaries from different policing agencies, from the DOJ, FBI, TBI here. And the question came about under Section I of the consent decree, whether or not we could coordinate with these agencies that do not follow the consent decree and are not bound by the consent decree, and to what extent we could receive information from them and what extent we could give them information that we acquired. We went to the monitor. The monitor felt like we were very limited in what we could receive from them and what we could also give those agencies. The judge, we went before the judge and he gave us some instruction at that time, and we looked at a number of times in which we work with other agencies, with the multi-agency gang unit, with Crime Stoppers, and we also worked with Shelby County Schools. So we looked at those situations, applying some of the logic that limited us with the symposium to those situations, and we felt it was a time to go to the court and vet these issues.
Did you get clarification, if you didn't get the full modification you asked for, but did you get clarification that that sort of communication is allowed?
Well, the opinion just came down, and it's about 49 pages, okay. and I don't want to speak definitively about the opinion at this point, but we did get some instructions from the judge. We did get some clarification from the judge about what we're allowed to do and the nature of the limitations we have and limitations that we don't have.
So let me go to Mike Rawlings. From a police point of view, the consent decree as it was interpreted up until now, okay, so we're still kind of working through this new guidance, limited you in certain ways from your point of view. That's what the mayor has said, that certainly. So from you on a practical level of out there policing and trying to fight crime and so on, what limits were put on you that you feel like limited your ability to fight crime?
So we know the presence of social media is just unbelievable now. And so if I think back to in the 1970s, there was no social media. There was no internet, no Blue Crush cameras, no body-worn cameras, no Twitter, Instagram, Facebook, none of that existed. So now we're it is my understanding that we're very limited in our use of social media. So here's my concern, that in a time where we've had a mass shooting almost every month, we still have the threat of terrorist activities, that the Memphis Police Department is being told that you cannot do what all other law enforcement does all over the nation. And my fear is that we're going to miss something, and someone's going to post something on social media, and because we're not looking, we're not going to see it, and some child is going to be harmed because of that. The other implication is when you think about child sexual predators. I'm really concerned, and also my fear is that we don't really have clear guidance on what we can do. As Mr. McMullen stated, this decision just came down last night. But we've been operating under this since the judge made his first ruling, and it's very cloudy. So, I don't know, do you have kids?
Oh, yes.
So I want you to think about this to where, if there was something that we could do, intercept something that alerted us to a possible school shooting or some type of child sexual predator, I think everyone would expect law enforcement to act. But if my officers fear that they can't use social media, and then that means that we're not looking, and my fear is that something catastrophic could occur.
Well, I think in that, you brought in, the example of the kids. I mean, I think everyone would agree, 99.99% of people would say, hey, anything to stop a terrorist threat, anything to stop a sexual predator. But when you've got a situation, we'll go with my kids. Like my son was with the bridge protest. My son, I did not know this, he was in high school then, he was up there for a time. That is, and back to that sort of notion of political protest and where the criticism of the police department that the police was monitoring people who were political activists or who just disagreed with the Strickland administration. That felt very, very different, right? The monitoring of social media of a political activist seems very different than monitoring the social media of a potential terrorist. So where are those lines?
So if you go back to the decree, and I think that, I have what the judge said, and I think there are a number of nuggets. The judge said, for the most part, the officers of MPD have demonstrated their dedication to protecting First Amendment rights, regardless of protest opinions. If you go back to the activists that testified, if the judge said that the ACLU did not provide sufficient evidence to prove that any of them were discriminated against, harassed, or whatever. So it is my contention that we monitored social media, we monitored a lot of open source information to protect those protesters, because when you have a protest, you have counter protests. And we have to leave this in the context of 2016. In 2016, we had the bridge protest. Very dangerous situation. Your son was on the bridge, and I tell him today, and I would have told him then, that's very dangerous, don't ever do that again. Somebody could have got killed. If you think about after 5 officers were killed in Dallas, and that was a peaceful protest until the gunman opened fire. The 3 officers in Baton Rouge, that was a peaceful protest until those the gunman opened fire. If we think about the number of threats that we were receiving, information from the FBI that individuals were infiltrating peaceful protests and had nefarious intent. So we had an obligation to protect our citizens, and guess what? Nothing happened.
All right, well, let's bring Bill in here.
Bruce, do you know yet if the city will appeal the judge's ruling on this?
I don't know yet, but I doubt it. What we got from the ruling was some insight and some instruction on how the court interpreted the consent decree. And I think once you read the opinion, you can see the court didn't quite interpret it the way the monitor interpreted it. Court didn't quite interpret it the way we interpreted the consent decree. And so it gave us some guidance. Our overall goal was to modify the consent decree to the extent that we could utilize modern day policing and protect citizens' First Amendment rights. So we had a two-part goal in wanting to modify the consent decree.
So can the police department get a tip via Crime Stoppers or from a citizen that comes to the police department and act on that under the clarification you've gotten in the judge's ruling?
Under the clarification, and keep in mind, we just got it, and there's a reading and vetting we need to do before we're definitive. But what I understood from the court, that we would have to verify that the information was not gotten in violation of the consent decree. So if you called in with a tip, and what we would have to verify that information was not gotten in contradiction to the consent decree.
So the scenario would be that it wasn't a police officer who might have violated this and surveilled someone and then called in an anonymous tip on Crime Stoppers or said, I got an anonymous tip. Am I correct in that?
Well, I'm not quite sure I understand your question.
In verifying an anonymous tip that the police department gets, do you have to make sure that it's not a police officer who has called in an anonymous tip to Crime Stoppers, not saying he's a police officer, and then the police department acts on it?
My understanding, it doesn't matter whether he's a police officer or a citizen. When they call in an anonymous tip, we would have to verify that they got this information consistent with the consent decree. And what's the question, we have to figure out, how do we verify that? So if you call in an anonymous tip, we have to ask, I would think we would have to ask, how did you get this information? And then we would have to do an analysis as to whether it violated the consent decree before we acted on it.
Let me interrupt you just to say, because of the timing of this, we are filming this Thursday morning. By the time this airs on Friday night, I will guess that Bill will have written a couple of stories, had a chance to read the consent decree, write about it. We would probably have it posted on our site. So I do apologize to viewers that we're doing this kind of in real time, but there'll be in the kind of between now when we tape it and when this airs, there'll be more information on the Daily Memphian site. You all have had more time, and Bill may have quoted you. So I would encourage viewers to go to to read up on this on dailymemphian.com as we fill in more information. But back to Bill.
The other big question to me has been the role of the multi-agency gang unit, where Memphis police officers work with law enforcement officers from other agencies and work with other parts of the legal system. By Judge McCullough's ruling in this, where does that stand? Can Memphis police officers get intelligence via the gang unit from other agencies that are not covered by the consent decree?
From my reading of it, at this point, the answer is yes, but we have to verify that information that we receive does not, their accumulation of that information did not violate the consent decree.
All right. Director, you talked about counter-protest and the instability that's represented by another protest coinciding with yet another protest for your officers and for the public. But some of the surveillance in this was specifically aimed at activists. It was specifically aimed at things like book recommendations that were made on Facebook. Do you think the police department went too far in that, or in having an officer open up a Facebook account under an assumed name?
Yeah, I think that's a great question. So I go back to the decree. So if you go back to the decree, the judge clearly says that the decree, the 1978 decree, imposes significant burdens on the Memphis Police Department. He also says it is an extremely high standard. So I think what's important is that no one's constitutional rights were violated. The decree, very difficult to abide by. So when you go back to these, some of the stuff that you've said I haven't seen, the decree talks about political intelligence and talks about the difficulties of navigating that water using modern technology. And I think that when, again, our officers, the judge clearly says that these mistakes were probably made because of our interpretation of the decree. And I think he talks about we needed to have done a better job training officers on the decree. But here's the confusion. You have an interpretation of the decree. The city attorney has an interpretation. I have an interpretation. But ultimately, the judge will tell us how this decree should be interpreted. Without this action, we still will be operating under probably some misinterpretation. And so the significant burden is that it is so confusing. My fear is that it's going to cause inaction because it's too difficult to try to figure out what is allowable, what is not allowable, what happens when you get this gray area, and if there's a threat to life and we pause, could it cause your child or your grandchildren to lose their life? That's my fear. Everything we did was for public safety. We never stopped anyone from expressing their First Amendment right. There are some people that are alleging we did certain things that have yet to be proven. So did we make some mistakes based on the interpretation of the judge's interpretation? We did. But we're here to try to do everything we can do to comply with the judge's interpretation of the decree. Obviously, if the monitor, the city, the judge, we don't all agree of the interpretation, we're trying to find that middle ground. It's much more complicated. And let me say just one more thing. In 1978, nobody wore seatbelts. Well, we learned that seatbelt saves lives. So everybody knows click it or ticket. So we found that something that was done in the 70s, we probably need to go revisit that and modify it and make it apply to modern police work. And that's all we're asking.
Bruce, your point on this, and it sounds as if this is still very much a process of figuring out what the terms from 1978 mean in 2019 going into 2020.
Absolutely, and I want to make 3 points. One thing that you picked up on, it doesn't limit what information we get from police agencies. It limits what information we get from third parties. So whether or not Conduit, the company that gets the video data that provides it to MPD, that is a third party. And one of our questions to the monitor was, do we have to verify that they complied with the consent decree in order to accept that information? The monitor felt that his interpretation was that it was. It did. The court gave us some more instruction on that, and we're working our way through that. So it's not just if a police officer called in the Crime Stopper, if any citizen. There are 3 scenarios in the mayor's newsletter, and all 3 of those scenarios are real scenarios that have happened in which we have gone to the monitor and we've gotten some limitation on our action. One thing I think the public does not know, when Director Rollins, someone on MPD, runs into a situation where in their mind they need guidance on whether this violates the consent decree, no matter what time of night, and I think the monitor will vouch for this, they will give me a call and they'll bounce the scenario off me. I will put it in an email to the monitor and then call the monitor. I have a special number to call him on. I'll call the monitor, we'll discuss it, he will give me a ruling right there, and I'll immediately call Director Rollins or someone at the police department, and we will handle that situation. A lot of times that happens late at night in real-time situations. I think the riots that occurred in Frazier, that was one situation where there were multiple calls to the monitor. Can we do this? Can we do that? Can we do this? The monitor has to make real-time decisions. We have to make real-time decisions. And our overall objective for everybody is to provide public safety and to not infringe on someone's constitutional rights.
So is there a distinction here, because a third party is not covered by the consent decree? Is the distinction here not that third party has the information, but how the police department acts on that information?
Well, the distinction is, how did they get the information? Did they get it consistent with the consent decree? Bill, if you call Crime Stoppers and provided a tip on something, my reading of the court's order, and I may amend that after I read it a couple of more times, is that we have to verify how that you got that information consistent with the consent decree. And you are third party, you're not a police officer, you're just a third party.
Does this, with the message, the ruling from the judge, the monitor stays in place? So now the monitor has guidance as well? Is that so? This process you're talking about of the back and forth with the monitor continues with new guidance in place for everyone involved?
Oh, absolutely. Okay. The monitor stays in place, and he is very responsive any time of night. We call him with the situation, right. And ultimately, the judge will see all those things and rule whether or not the interpretation by the monitor, and you'll see in the opinion, the interpretation by the monitor, our interpretation, and our interpretation of what the monitor said was correct. So it gets very complex.
One thing that was, I think, I don't know, that others found disturbing or questionable or just were surprised by is when the police department had set up a fake Facebook account or social media accounts to kind of essentially friend other people on social media to understand what they were doing and get insight into that. Is that allowed?
The court has said that is not allowed, so that is not,
and that
not
wasn't
allowed.
Changed in this.
Right, but we also worry about the circumstances of that. How do you handle dealing with sexual predators online if you have to say, I am Mike Rollins, Director of Police?
Right.
So there are unintended consequences that we are struggling with. The Bob Smith account you were talking about, the court has said that is not allowed, and that's a violation of the consent decree, and that action has ceased.
But again, even the notion of, again, it gets back to, this isn't just about, terrorists and sexual predators. It's also, and violence. I think we all oppose to those things. It's also about people who are just going about their day, people who are opponents of the Strickland policies on taxes or pilots or whatever the heck it is. So what are the checks and balances in place that political differences aren't being monitored and filed, and sort of profiles and records being kept on them simply for their political differences? And yeah, that might turn into some sort of rally or some sort of march, but again, that's still not violence.
I can tell you, I've been involved in this since the initial ruling, and there's no evidence, and the court says in his opinion, in the first opinion, that there's no evidence that the person's political point of view had anything to do with MPD's action. So that has never been an issue, that has never been proven by the court. Proven in court, and I have never seen any evidence that a person's political opinion drove any actions by the city or MPD.
2 minutes left. Let me go back to Bill.
Director, can you do sting operations? Can a police officer pose as a John in trying to make prostitution arrest?
So it's my interpretation that we still can do a sting type operation. But again, it's still cloudy. So we're still operating in a gray area, and I think that, again, it limits our ability to provide good police service. And again, I think that we're simply asking that this outdated decree be modified. The decree never had an expiration. I don't know many decrees that don't have some type of expiration. So it could go on forever. We don't know what type of technology is going to come out, how people are going to communicate. So we just think that decree should be modified so we can do modern policing and keep our citizens safe. So, and the other thing I think we need to think about is, with all the cameras that people are asking for, I think the county just approved another large sum of money for cameras, and that there are implications to all of this. And so I'm concerned that, will we have to pull these cameras down? Will we have to do something different with our body-worn camera in-car video program? Is there something we're going to miss? Most people don't know that we've responded to, I think the number's 94 threats to schools, churches, businesses, public officials this year. And most of those tips come in the middle of the night, where we're trying to get law enforcement in place before the school bell rings. And folks, significant burdens to what we do have been put in place by this decree.
All right, on that difficult note, we will end it there. Appreciate both being there. And again, more news on our side and others as we digest and report on this ruling. Thank you for joining us. Thank you, Bill. Thank you both. Join us again next week.